5 seconds to go. Start. There was no occasion for the settlement of any accounts on 7th August 2006, resulting in a full and final settlement of the claim. If the parties have had business dealings from the year 2001 2002, it is hard to believe that a part of the amounts that flowed out of the account of the plaintiff was out of love and affection. The only piece of evidence on the basis of which the gratuitous nature of payment is sought to be proved is Exhibit D3, but it does not contain the signature of the appellant. Therefore, the plea of gratuitous payment is unbelievable and was not established by the respondents. Once the plea of gratuitous payment falls to the ground, Section 70 of the Indian Contract Act 1872 will come into play. Section 70 reads as follows: obligation of person enjoying benefit of non gratuitous act, where a person lawfully does anything for another person or delivers anything to him not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered, as held by this court in the state of West Bengal versus B.K. Mondal and Sons. Section 70 is based on the premise that something was done by one party for another and that the work so done voluntarily was accepted by the other. Therefore, as a corollary, the plea that there was a subsisting contract in the nature of business transactions is antithetic to the very essence of Section 70. This is why Section 70 forms part of Chapter 5 of the Indian Contract Act, which is titled as of certain relations resembling those created by contract. As pointed out earlier, the respondents have admitted that the monies as claimed by the appellant plaintiff were either paid by the plaintiff or flown out of the plaintiff's account into their own account. Therefore, the onus was actually on the respondents to prove either a discharge by way of settlement of accounts or the gratuitous nature of the payment. The respondents miserably failed to discharge the onus of proof so cast upon them. Hence, the plaintiff appellant is entitled to a decree despite a few discrepancies in her evidence, especially when the discrepancies have no bearing upon the payment flow of monies from the plaintiff to the defendants. In view of the above, the appeals are allowed. The judgment and decrees of the High Court are set aside, and the judgment and decrees of the First Appellate Court are restored. In other words, there will be a decree in both the suits as per the judgment of the District Court Chandigarh dated 18th March 2015 in civil appeal numbers 903 and 1056 of 2013. Stop.